and Kashmir can do nothing in their constitution, or even Parliament can do nothing in their constitution. So I really appreciate, my lord, the difficulty, my lord, if your lordships accept that. Then even 368 route, which is the second route suggested, cannot be done. Because it says one and this article shall remain. If that is the meaning given, that is completely unalterable, then 370 remains as a permanent, though there are a host of considerations for me to show that it has always been a temporary feature. Further, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. My lord, other provisions would mean other than B.
Yeah, just stopping you for a minute. Could the Legislative Assembly make a recommendation in terms of 371A saying that under 367 you equate Constituent Assembly with Legislative Assembly?
Under 371?
What D? 370 sub clause 1 subclause D. Could the Legislative Assembly make a recommendation saying?
If it is amendment, it cannot. If
Just think about it and then answer. Could the Legislative Assembly make a recommendation to the Parliament, please amend Article 367 and
let me give it a thought and my lord respond to that. My lord, that I understand the heart of the matter. Your lordship's discussion, my lord, is driving that any 367 use which has the impact of altering 370 itself, then, my lord, we would be setting at not all 367 usages. But kindly remember, through the 367 mechanism, 370 has been modified.
That's the point in favor of what you are saying, with the caveat that the use of the 367 mechanism to modify 370 was always with the consent.
Concurrence.
Sorry, consent.
Here also it is concurrence. The only difference.
It was concurrence.
Yes,
That's
this is
the very one. That is constitutionally the significant difference.
But this is
Now, what
also
is
with concurrence.
See,
look, this is also with concurrence. The only difference is the concurrence of the governor, because governor steps into the shoes of the government.
So there's a difference between concurrence and recommendation.
Correct. But
Concurrence can be subsequent, recommendation has to be.
no, recommendation is of the body, Constituent Assembly as it stood, and subsequently, if we are right, Legislative Assembly. Concurrence of the government. Please see, my lord. And government, the only dispute was that government cannot mean governor. Please see, my lord, concurrence provision, second
The
provision.
concurrence of the government means that Council of Ministers.
Council of Ministers, if it is there, otherwise powers are exercised by the governor. And that's why, my lord, I pointed out that there are several exercise of 371D when there was a precedence rule with concurrence of the governor.
At least you have provided yesterday.
At least,
At least you have read it yesterday.
yes. My lord, your lordship's query is, my lord, absolutely, my lord, dot on the point. But, my lord, I'll respond, my lord. Let me give it a thought. But the real question would be,
You have already responded.
well, the real question is, my lord, that here concurrence is that of the governor. Government, whichever is the government, if it is ministry, then cabinet, aid and advice, otherwise the governor. And during governor's rule, 371D is used to change 367 also. To not change, change is a incorrect word I have, to put an explanation, to give meaning to 370.
so simply put, according to you, at a time when there was no legislative assembly, the explanation was amended so as to incorporate
Democratize.
so as to provide that the Constituent Assembly shall itself be treated as the Legislative Assembly.
Because it was so treated
Because the
early.
Constitution had not been framed and there was no Legislative Assembly in the state of Jammu and Kashmir. So according to you, the flip side now is that when there is no Constituent Assembly, we treat the Legislative Assembly as a Constituent Assembly.
To democratize, my lord. Otherwise, my lord, kindly see, suppose the government took the decision. The government took the decision, my lord, suppose,
The second answer could be, and that's for the other side to answer, by amending 367, in fact, you're not really amending 370 as such, because the 370 procedure has to be still applied to abrogate or nullify 370. The procedure has to be still applied. Suppose 367 had been amended in terms of 371D with the concurrence of the state government. Second step, the Legislative Assembly had made a recommendation, please abandon or abrogate 370. It would have passed muster. Nobody would have really, probably the other side wouldn't have been here also, except some of them.
yeah, they would still be here, my lord, but
So they would-
that's beside the point.
But it could have been done. If this route is permissible or not.
Lord, I'm putting a question to myself, my lord, suppose.
I
we-
thought I answered it in your
Your
favor.
lordships are absolutely right. That's my answer, my lord. That's my answer, my lord. I'm grateful to your lordships, my lord, for that. That thought didn't occur to me. But, Lord, suppose we took the decision that in view of the proviso becoming otious, because there is no constituent assembly, that limitation of recommendation, ultimately it's recommendation. Suppose it recommends that don't abrogate, president is not bound by it. So now the constituent assembly having chosen while being dissolved not to recommend, the constituent assembly has left it to the absolute discretion of the president. It could have been done, my lord, possibly it could have been defendable action, but with a view to ensure that there is democratization of the action. And my lord, your lordships are dealing with the state of, this is a provision which is one of its kind. There is no such provision either in our constitution or in any constitution. So the law which your lordships would ultimately lay down is not going to, Lord, touch upon any other provision. If suppose the Commonwealth Constituent Assembly, while it was being dissolved, if it framed the constitution, it had options, my lord. A, don't abolish, I am recommending that president should not exercise powers under sub-article 3, he should not abrogate 370. That was the first option. Second option, he should abrogate article 370 after 5 years. Till then, let the constitution continue. Third, the president is, we recommend that president should modify some of the provisions which we recommend and continue 370 as it is forever. Having done nothing of this, the Constituent Assembly goes without making any recommendation and therefore leaving it to the absolute discretion of the president.
Solicitor, you said that the president is recommendation.
It's a recommendation, my lord. It's not.
But you see the words used in the proviso. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary.
Yes, Lord, why I say this, Lord, kindly see the second proviso, where concurrence word is used. Concurrence means I have to say yes, otherwise you cannot do it. Therefore, I am contrasting the word concurrence with recommendation. Consultation, yes, the concurrence is at the highest level. That without consent, concurrence means consent. Consultation may sometimes means consent, may not mean consent. Your lordship has seen Justice S.H. Sheth's transfer of judge's judgment, where it says that consultation can even mean concurrence. So I am not just contrasting the word concurrence with recommendation, that the same provision uses the word concurrence, means unless the state say yes, president can do nothing. But here same provision uses the word recommendation, that you will recommend. Ultimate power with the president who is answerable to the House which is answerable to we the people of India. So highest executive functionary is conferred with this decision, and we can read that in absence of Constituent Assembly and its recommendation, the proviso goes. It becomes redundant. It becomes otiose. It becomes not possible of being implemented. And law doesn't require performance of an impossibility. But considering the nature of the strategic importance of the state, it was felt necessary that let this be debated in both the houses of parliament. And Rajya Sabha is, my lord, house of people. It has its own federal structure. Every state has a representation in a different indirect election form. And both houses passes, my lord, with 2/3 majority. Lord, even Constituent Assembly could have recommended that word temporary be deleted. Even clause 3 be deleted. Why not? There was no embargo. During the subsistence, during their existence, and while being dissolved, or during that period, they could have said that delete temporary provision, delete Article 3. Now we don't want anybody's power to abrogate. They could have said even C can be deleted. Suppose, my lord, the Constituent Assembly were to say that delete 1C, that Article 1 is untouchable. Because now we have our own constitution, we no longer are integral part of India. Lord, it could have said, technically it could have said that. But Section 3 of the Constitution says, no, we are an integral part of India. They never said that President's power under 3, we recommend being either diluted or taken away. They never wanted clause 3 to die. That's very clear.
All right. So we've covered now the first point, the interpretation of 370.
My lord, 370, my lord, there are some points, my lord, if your lordship permits.
So on 370, Mr. Solicitor, why don't you summarize in 3 or 4 propositions? What's the heart of your submission?
Can I, my lord, do one thing if your lordship permits? My lord, I knew, my lord, I'll be running against time. My lord, instead of, my lord, my 40, 50 pages of, my lord, explanation and arguments, I have summarized in 4 pages.
Right.
That would, my lord, save your lordship's time also in, my lord.
So you have it here?
If I can be permitted, my lord, I'll just quickly go through.
5 minutes and we are done with
Yeah,
370.
yes. You can. Says, my lord, it declares it to be temporary. Your lordships may not read anything, my lord. It is contained in part 21, which has 3 categories: temporary, special provisions, and transitory provisions. So constitutional framers are aware of what word they are using. My lord, second, I have said, my lord, I have already said, and this is, my lord, something very, very serious. Look at the width of the power. 2 individuals in practice, and legally speaking, 2 organs, namely the president and the state government, can alter any part of the constitution and apply it to one part, can delete any constitutional provision, can create a new provision, and therefore, my lord, the submission is, considering the very expanse of this provision, the constituent framers would never have, my lord, contemplated this to remain forever. Such a position can never remain forever, where our constitution remains a floating document perennially for one state. Then 3, impact of Article 370 was to deprive the residents of Jammu, Kashmir and Ladakh from being treated at par with their fellow citizens. My lord, therefore, my lord, I am saying that This also is one suggestive indication that framers never intended it to be
Permanent.
permanent. Then, Lord, this is the entire provision. Lord, this is very important. This is the entire provision in the Constitution where application of not only Constitution, please see this, my lord, the seriousness of this. Application of Constitution of India and application of central laws, including beneficial legislations, is dependent upon concurrence of the state. The only provision. It says it would not apply, it will not apply. Such a, my lord, drastic provision could never have been intended to remain perennially, permanently. Then, my lord, this is the only provision which has an inbuilt self-extinguishing provision, sub-article 3. No other constitution provision has this self-destructing clause. This again, my lord, is a pointer that it was intended to be temporary. Then, Lord, it is goal of equivalence, my lord, I have already said, my lord, in the judgment which I read, that temporary problem, my lord, provision cannot be read so as to treat one part of state differently, their citizens differently. Then, my lord, your lordships would not give interpretation to a temporary constitutional provision having such drastic consequences. Because your lordships are not going to be confronted with a similar situation in future. There is no other provision in the Constitution. And to our knowledge, any other part of the world where a provision of a constitution of the main unit applies only with the state consents. In a federation like ours, there cannot be any such provisions. My lord, then I have said, my lord, kindly examine it from the people's angle. Then 370 is interpreted the way petitioners interpret. 371 would become permanent, which is not only impermissible and not envisaged, but would result in the unconstitutional provision remaining in the Constitution and operating. Well, unconstitutional, why? It discriminates. It confers an authority which is never contemplated in other states. The application of the Constitution of India given by we the people would either not apply fully or would apply. My lord, I am on 10, point number 10. My lord, I would request if your lordships can read with me, my lord. The petitioner's assertion that such a huge decision is taken purely by an executive fiat is absolutely wrong. The process followed clearly reflects participation of entire nation through their chosen representatives, both in Lok Sabha and Rajya Sabha. When a decision becomes concerns a federating unit, it is of strategic significance, what I have pointed out. My lord, then 13, my lord, is most important, my lord. Sub-article 3. The proviso to sub-article 3 was to remain in operation. My lord, I have already said these are the 5 possible recommendations that Constituent Assembly could have given. Your lordships have seen that. Then, my lord, B. Once the Jammu and Kashmir Constituent Assembly ceased to exist, the proviso to Article 370 sub-article 3 itself ceases to exist and the President becomes the sole repository of power under Article 370 sub-article 3, which is coupled with his duty to exercise in the interest of residents of Jammu and Kashmir without any recommendation. It is for this reason that power is conferred upon the highest political executive who is responsible to the Parliament, who in turn is responsible to we the people of India. It is thus clear that Parliament, while framing the proviso, merely gave an option to the Constituent Assembly to make recommendation till its life. But 15 is important. This is how the petitioners want your lordships to read. Notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly of the state referred to in clause B, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications. The very purpose that the concept of recommendation is provided in the proviso Lord, leads to an inevitable conclusion that they wanted it to leave it an option to the Constituent Assembly during its life to make some recommendation. Otherwise, that proviso goes. Lord, they
According to you, the proviso will not govern the substantive provision.
cannot govern. Yes, my lords are right. I am obliged, my lord. If the proviso become OTOs, the main provision does not become OTOs. Then the conditionality attached goes. Tail cannot vary. Yes, my learned friend is right. If this interpretation to Article 373 is not accepted and the President's power is under Article 373 is taken away, merely because the Constituent Assembly has ceased to exist, without making any recommendation, it would create a devastating situation which could never have been envisaged by the framers of the Constitution, nor ever been conceived. If the President cannot exercise the powers under Clause 3, it would mean that existence and exercise of power of the President of India provided for in the Constitution is dependent upon some decision or lack of it by a different body. My lord, can we read a Constitution that President's decision is dependent upon some outside body takes a decision or does not take the decision? If it takes, it's an option. If it doesn't take, you lost your option. The President of India cannot be denuded of its power by either they giving recommendation or at least not in absence of recommendation. Such an interpretation would never be given, as such contingency could never have been, my lord, conceived. Then 17. Secondly, if mere absence of Constituent Assembly mention in the proviso to Clause 3 is treated to be rendering the power of President of India nugatory, redundant, and unexercisable, it would mean that by using any provision under Article 371B and 1D, any provision of the Constitution can be amended and applied to the state of Jammu and Kashmir, and even the provisions which are part of basic structure, please mark this, my lord, this is what fell from my lord Justice called, that you are putting it at the higher threshold than the basic structure. Basic structure cannot be altered by constitutional amendment, but there is no such limitation in 1D. You can, they have chosen not to apply some of the fundamental rights, meaning thereby a permanent power is vested on two organs of the state to alter even the basic structure so far as its application to the state of Jammu and Kashmir is concerned. And this is very, very serious. Now, of course, my lord, it can never be done. Now all are at par. Even if the Constituent Assembly would have been in existence, the limited role stipulated, my lord, that I have already said, my lord, it is only recommendatory, and my lord, President could have taken any other decision.
That may not be correct actually, because so long as the Constituent Assembly, it was not recommendatory. Look at the way the article is couched. Provided that the recommendation of the Constituent Assembly of the state shall be necessary. So it's not recommendatory in that sense.
I'm sorry.
Constitution always, let's put it very, Constitution as a supreme document in a democratic country will always place restriction, whether it's the judiciary, whether it's the president, whether it's the legislature.
Lord,
It's all
I
place.
bow
That's-
down, but
that's-
my submission,
Constitution is governance by limitation. With
And-
limitation.
And the use of the words recommendation shall be necessary is a clear indication that it's not merely recommendatory, but that there has to be a recommendation before you exercise.
can your lordships read it a slight differently, the way, my lord, I read it? What is mandatory, the word shall, that you take recommendation. The recommendation is not binding, my lord. Otherwise, the Constitution would have said that it would and act accordingly. What is mandatory is taking the recommendation. That's another way of, my lord, interpreting.
So the other part of the argument, we understand that the proviso, after the Constituent Assembly had done its job, is no longer applicable, but it doesn't affect the main part. We have main clause 3, we have, we'll examine that out.
Yes. Now 19. The only constitutionally compliant way of interpreting Article 370 to achieve the ultimate goal of bringing the people of Jammu and Kashmir at par with the rest of the country and conferring them with all constitutional and statutory rights at par with the rest of the country is to either read an unfettered and plenary power of the President of India under Article 370 sub-Article 3 once the Constituent Assembly ceases to exist. Just now, Lord, I pointed that out. Or modifying the 370 sub-Article 3 by replacing the successor body. We went for the second, which according to me was not necessary. It could have been done without, my lord, any recommendation also. Lord, then power of the President under sub-Article 3 is unfettered, as Article 370 starts with a non-obstante clause, notwithstanding anything contained in the Constitution of India, and sub-Article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing provisions of this article. But kindly see this, my lord, something my lord, that might, my lord, throw some light, my lord, on the first discussion, my lord, which my lords, my lord, the Chief Justice, very, my lord, enlightened discussion. Lord, 370 starts with a non-obstante clause. There's nothing in this constitution. This is how the 370 would function. 370 sub-Article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing paragraphs. Meaning thereby, even 370 can be subjected to 370 sub-Article 3. Look, kindly, Lord, read it once again, Lord. I do not know.
Obviously, because 370 clause 3 has a non-obstante clause which overrides everything else in this in this
Even
article.
1D,
Right.
even 1D, which says that don't do anything except 1 and 3, and
There are two non-obstante clauses. The first is notwithstanding anything in this constitution. And 370 clause 3 says notwithstanding anything in this article. Therefore, it overrides, therefore, it's a power to override even clause 1.
clause 1, yes, clause 1, 2, 2 doesn't come, my lord, 1D also. Lord, your lordships, Lord, very illuminating.
But there can't be any doubt about it, because when 370 clause 3 says notwithstanding anything in this article, that would include clause 1. There's no
Lord,
difficulty about that.
meaning thereby, modification in 370 itself was permissible through 367.
And when you override clause 1, the plain intent therefore is that the constitution itself becomes applicable then.
Correct.
Once you exercise the power under 3, whether there was a valid exercise is what we have to decide. But once you exercise validly the power under 3, then the constitution applies. That would be the plain consequence of it.
My lord, your lordships may treat this as read, my lord.
Yes, we'll read it.
My lord,
Let's
I
go
don't
now
wish-
to the last
my lord,
point.
only, my lord,
Now,
last
reorganization, Mr.
my lord,
Solicitor.
last 2 pages, my lord, last 2 pages. The status of Constituent Assembly. What was the status of Constituent Assembly? Because nomenclature is a Constituent Assembly. But whether it enjoy, my lord, I am at the outset, I
I'm
mean,
not saying that it is subordinate to the Constituent Assembly for the Union. I mean, you can't elevate that Constituent Assembly.
Lord,
to
I
a-
must clarify one thing as an officer of the court. Lord, I am conscious of the principle laid down in Keshwanand Bharti, that there is a distinction between Constituent Assembly
and a
and Parliament,
legislative assembly.
or Constituent Assembly and Legislature. They are not interchangeable. That's why, my lord, this submission, that here Constituent Assembly for all intent and purpose was a legislative assembly, not preparing a document of governance for a sovereign region, but was, my lord, kindly see, my lord, there are some arguments based on, my lord, the judgment also, my lord. My lord, the position as far as the state of Jammu and Kashmir is concerned, even prior to coming into force of Article 1, was who created Constituent Assembly? The Maharaja who signed instrument of accession and surrendered his sovereignty. Then he issued that proclamation. Your lordships are, my lord, remembering that now whatever constitution is framed would be binding on him. He subsequently, my lord, creates a constituency. So he could never have created a Constituent Assembly which would have a role independent of, larger than, or completely different from the Constituent Assembly of which he became an integral part. And At that time, my lord, the Jammu and Kashmir was an integral part of India. So the body which was created was known as Constituent Assembly, but was a subordinate creature, then, my lord, Constituent Assembly. And the Constitution of Jammu and Kashmir can never be put at the same pedestal as the Constitution of India, because the very birth of the Constituent Assembly of Jammu and Kashmir was because of Article 37. And, my lord,
In other words, according to you, the role of the Constituent Assembly of Jammu and Kashmir is the role which is created for it by our constitution, by the Constitution of India,
of
nothing
India.
beyond that.
It cannot be beyond that, above that, or superior to that. It is subservient and subordinate. It never had original constituent power. My lord, please see, my lord, the constitution as we understand around the world, my lord, has certain attributes. Namely, it must be a document of governance, providing for everything the way, my lord, we have provided. This constitution has only certain aspects. Rest, my lord, they leave it to the Constitution of India. For being recognized as a constitution, you must provide for a kind of sovereignty. I'm not on, my lord, sovereignty means sovereignty, my lord. It's not autonomy. And sovereignty would mean right to acquire new areas and right to cede new areas, right to acquire territory and right to cede territories, which we have in Article 1, 2, 3, 4. Constitution of India has. Lord, none of the attributes of a constitution, so to say, Lord, can be attached to this constitution. It was a piece of legislature recognized, accepted, and known till 5th of August and 6th of August 2019 as constitution. But for all intent and purposes, my lord, it was, my lord, even the preamble of the constitution doesn't say so. A preamble of Constitution of Jammu and Kashmir doesn't say so. That this is a document which is a constitution. It merely says, Lord, please see the preamble of Jammu and Kashmir Constitution. It says, with a view to further define our relationship with Union of India. It doesn't say that we are creating a constitution of our governance. Please see, Lord, that's the only purpose. They say, we the people of Jammu and Kashmir, with a view to, I'll just read for your lordship, my lord. I'll just read, my lord. It is, kindly note the page. Volume 2, page 16. Your lordship need not open. I'll just read. Even preamble doesn't say that it has attributes of a constitution per se. We, the people of the state of Jammu and Kashmir.
Mr. Solicitor, there is another more fundamental reason why your argument may be correct, which is this. Look at Section 5 of the J&K Constitution. It says the executive and legislative power of the state extends to all matters except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India. So once the Constitution of India defines which is the area in respect of which Parliament has the power to make laws, then that is denuded from the jurisdiction of the Jammu and Kashmir Legislative Assembly. Now we have seen how progressively the ambit of the legislative domain of Parliament was expanded. For instance, initially the entire concurrent list was outside the power of Parliament.
Correct.
You had only certain entries in list 1, the union list.
I am obliged.
Right? Subsequently, the concurrent list was brought in. Once the concurrent list is brought in within the domain of Parliament, to that extent, the legislative domain of the Jammu and Kashmir Legislative Assembly is denuded. Then entry 97 was wholly outside the purview of Parliament initially. Later on, as we see, entry 97 is also gradually brought in within the purview of Parliament, albeit in the context of laws affecting the sovereignty and integrity of India,
Some subject.
terrorism, so on and so forth. Therefore, it's very obvious from Section 5 of the J&K Constitution that once the Constitution of India prescribes a certain legislative domain for Parliament, then that is progressively denuded from the legislative ambit of the J&K Legislative Assembly. And that was not fixed as of 1957. Another very important feature is that Section 5 does not fix the ambit of the legislative or executive domain of the J&K government and the Legislative Assembly as of 26th of January 1957.
Correct.
In fact, it contemplates that what the Constitution of India